And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
Hey, and welcome to the show. I'm Zach Spencer, and we are talking about estate law and estate planning on this week's show, and we're getting into trusts. And joining us today from LakesWhyteLLP in North Vancouver are John Lakes and John White, joining me to talk about the basic rules when it comes to executing a will. So trusts, we should sort of maybe explain that trusts are different than a trustee. There is a difference there, right? So can you explain the difference?
Well, Zach, yeah, in a will, you may want to create a trust. So, for example, we'll talk about your situation.
Mm-hmm.
So, you have children under the age of 19. So, if you and your wife are killed going to Las Vegas or something, and you don't have a proper will, then your funds would be paid to the public guardian trustee, which is a government office, and it would sit there, and your kids would each get a big chunk when they turn 19.
Okay.
Which is not what most people want. So, a typical will for people with kids under a certain age would, first of all, they'd be appointing a trustee, and that's somebody you trust. So it's somebody who lives in British Columbia, maybe your brother, maybe your sister, who will have the authority to hold the funds until your children reach a certain age, such as 25. They have the right to pay both income and capital on the behalf of the children. You could have special clauses in there. So, for example, if your children go to private school, if your children are high-end gymnastics or something very expensive, you could give them the authority to pay those funds, and then when your children reach a certain age, then they get the balance of the estate.
Could it be also decided by the trustee that maybe they would be better off in a private school and use funds towards tuition?
Well, you can put that in, and sometimes there could be, every will is unique to the circumstances, and usually if people want their children to go to private school, I'll put a clause in their will to allow that. Another thing I'll do sometimes is, let's say, if your spouse's family are from London, England, you may put a provision in the will that will allow your trustee to let your children travel to England once a year with another adult with them, so they can maintain contact with their relatives in England.
And that would be paid for by the estate.
By the estate. Or let's say if the family has a cottage at Whistler that you think it's really important, you may give the trustee the right to retain the cottage at Whistler so the kids can use that as well too. So
can I give you a situation? So say something happened to my wife and I, and my children are young teenagers, 13 and 11, and we're not there, but we would like them to stay in our home until they're older. So how do you handle that, and who's going to move into the house with them, and those sorts of things?
Well, I could put a clause in a will that says allowing to maintain the certain house, and that the guardian can live there as well, because in the will you're also going to appoint a guardian as well too. Right. But you can put that authority in there, and that's fairly common, because let's say if you're going to name your sister as the guardian for your children, she lives in a one-bedroom apartment in the West End. Maybe it's better for them to live in the house too.
And you want them to live in the same neighborhood with their own friends and all that sort of stuff.
So in a proper will, you'd cover that situation. So because your children are already suffering from the trauma of you and your wife both being gone, you want as much continuity as possible too. So at the end, the trustee is going to administer that, and they can decide, well, yes, I'll pay for your daughter's braces, but no, we won't pay for her tattoo for her boyfriend. So
that's probably a good idea.
So.
And who's the advocate on behalf of the children in that case? It's the trustee. Well,
the guardian. Sometimes the guardian and trustees are not always the same people. Sometimes it's a bit of a conflict, because I've had situations where somebody's both a trustee and a guardian, and normally if you're a trustee, you should be paying the guardian a check every month, like maintenance, to pay for everything. And sometimes what happens, if the trustee is also the guardian, they don't pay themselves enough money, and they actually use their own money to support your children. So, or
you could have the opposite, where they're paying too much.
Yeah. So it's, and then also the trustee has to provide an accounting to the public guardian trustee's office every 2 years as well. So, which is a government office who think that.
And how close do they scrutinize these things?
Well, sometimes they look at it pretty closely. They look at the will, and they see what the powers are in the will as well too. So You know, you get into difficult things like, for example, if your daughter's a high-end gymnast, I mean, really, is it appropriate to pay $15,000 for her to attend a competition in Atlanta and things like that too? So you have to look at what you're, and even with people with wills, they, you know, sometimes what your kids are involved now is totally different from what they'll be involved in 10 years from now too.
Mm-hmm.
I mean, John's kids are always doing different things, right?
Always.
Yeah. So
do you ever get in a situation where, you know, what was set out in the will for these underage children has changed substantially, and you have to go to court to say, well, what happened when the parents died has changed now, we want to do something different? How much leeway is there with the trustee with those funds when they're underage?
Well, there can be considerable leeway, but one of the things a trustee can always do, and in a situation of doubt like that, where you're having to ask that very question, is go to court and seek directions. I mean, the courts have a power given them under the Wills, Estates, and Succession Act, or the Trustee Act, I should say, to basically give directions to a trustee who perhaps isn't clear on what he or she should be doing. And that can be important later on. There are situations in which trustees can be found to have breached their trusts and can be personally liable in some cases for breaches of trust because they've obviously done something wrong. There's an escape clause for people in that situation where the court can find that they acted honestly and
they tried their best.
Yeah,
right?
They tried their best, but I mean, one of the things the court's going to look at it, you know, did they apply for directions? I mean, it's an opportunity for them, if there's doubt, to resolve that doubt. So why not do it?
And so, but then you're putting the direction of these children's lives in the hands of a judge.
yeah, but that's sometimes where you need to, because, for example, let's say your child gets a scholarship to go to Yale.
Right. Big ticket.
A big ticket item, okay? If they stay at school here, it's X dollars. You may want to say, go to court and say, can I do this? Mm-hmm. And then at least the court has given you permission. Instead of paying $15,000 to post-secondary education, you're paying $60,000. And
But I'll just play devil's advocate, and then the court says, well, no, that's not a good idea, and then you're stopping the child from going to Yale.
Well, they can still get a student loan. It just isn't paid for out of the estate.
Right.
So
yeah, but if the court says it's not a good idea, the court probably has a reason for that.
There's probably not enough money in the estate, right?
And it probably isn't a good idea.
Right.
So. But the other thing too with trust for children, you can spread the payment out. So the problem with the money with PGT, they get the big check at 19. However, let's say you've got a substantive estate. You may say, okay, my children get 1/3 at 25, 1/3 at 30, and 1/3 at 35 as well. So you can do that in a trust as well, and it gives you a certain degree of latitude. And then you also have to consider how long the funds are held in trust. So, for example, if your youngest child's 7 and your brother's 69, you may want to have a backup in case your brother doesn't survive the length time of the trust.
Now, what's the say there's a big life insurance policy paid out, several $1 million, for example. That's cash clear to the estate, right, or to the beneficiary. Say it's the estate. So what would happen with the trustee's job to invest that money?
Well, there is provisions under the Trustee Act that is fairly restrictive, and then you can also create trust powers in the actual will too. So they're fairly conservative where they can invest. I mean, your example was with Nortel stocks, which of course at one time was blue chip. They are not anymore.
Right.
What I do with some of my clients who are in high tech, like a lot of them have stock options. And so I'll provision in the will that allows the trustee to exercise stock options, because sometimes that's not normally an investment you're allowed to do, but you want to continue that.
Because you have to wait the 5 years for them to vest, right?
Or else if you're in the mining industry, you own a lot of speculative stock, you put a provision in the will allowing your trustee to continue to hold those stocks. So you've got to look at the circumstances. And I mean, the next type, but you may also have a trust for adult children that you may want it to continue. So, for example, let's say you've got a child who's got a disability, who's got Down syndrome or something. You may need to create a lifetime trust for that child. which in that case it's important that there's a gift over. So you create a trust for your daughter Marianne, but you want to make sure when she's passed away that who the funds receive at that end.
And then how do you do it so for somebody that's got a disability and they're, say, 25 and they could live to be 70 or 80 years old, that the money is paid out evenly over that time?
Well, that's the job of the trustee. Now, the other thing that's important too is if the children are receiving benefits from the government, they want to make sure they can deal without interfering with those, and those change from time to time. So this is where it's really important when you appoint your trustee that you appoint somebody who can, because the rules could be totally different 5 years from now than they are now.
So you're saying you wouldn't give them so much money that would preclude them from being accessible to grants and things from the government?
Well, hopefully not. But on the other hand, if there's enough monies, sometimes people are quite happy to get off the program. So then they don't have to have the government telling them what to do.
Yeah.
But again, you have a situation. So let's say you have a child who's mentally handicapped, and you're appointing your brother as the trustee. He's got a 16-year-old son who seems pretty responsible. You may take a gamble right now and say, okay, if my brother dies, then Johnny can be the backup, because you then at least have, because again, if you don't have a backup trustee, you may have to go to court to get a new trustee appointed, or the public guardian trustee could take over as well, which is not the best solution.
Especially for somebody who needs special care.
Well, John's just been going through a case right now where there's a dispute over who the executor is and trustee, and it's really created a problem.
It's still going on.
All right. Well, we're not going to talk about it just now. We'll talk about it after the break, because we want to talk about, we can touch on that case in a moment. We've talked about adult children. We're going to get into spouses and the execution of will and signing and how important that is. It's all about estate law and estate planning today with John Lakes and John White from LakesWhyteLLP in North Vancouver. And we will continue the conversation on The Law Show next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.